Now call forward the attorneys in case number 124471, State of Kansas versus Davontra Alston.
Mr. Alston appears by counsel Michelle Davis. May I please reserve 2 minutes for rebuttal?
2 minutes is granted.
Hopefully you can hear me okay.
Yes.
Okay, I probably shouldn't have messed with that. This is Mr. Alston's direct appeal from jury trial convictions for several crimes, including premeditated murder. Based on a shooting that Mr. Alston was not present at, the circumstances of the shooting is that one car is following another car and one car turns right. It's the driver ends up being deceased. The other car turns left and shots are fired out from the other car while the car's turning. That go through the back windshield, striking Mr. Alston, striking the deceased and killing him. The state's theory, so Mr. Alston wasn't present at the shooting. The state's theory was that it was Mr. Alston who procured the men to commit the shooting. And the defense in this case, the state's evidence, you can infer from the state's evidence basically that the deceased left the house belonging to Mr. Alston. And there were other people also present at the house. There was a gentleman by the name of, let's see if I can find. There was another gentleman at the house who was also involved with a woman who was involved with the deceased. Also present at the house were the woman and the other man. And the defense theory in this case is that the other man could have been the one who said, you know, he's here at the house or he's leaving the house from which the other car followed. So that was the defense in this case. Defense counsel also raised the claim that the state, based on the state's evidence and based on the prosecution, that these convictions should only be for conspiracy to commit the premeditated murder and should not be for the actual premeditated murder or the discharge of a firearm at the vehicle. And again, Mr. Alston was convicted of those crimes, the premeditated and the discharge, based on a theory of aiding and abetting. And so the jury was instructed that Mr. Alston was liable for the conduct of another if he aided in the commission of the crime or he advised, counseled, hired, or procured another person to commit the crime. And in closing argument, the prosecutor told the jury that Mr. Alston was guilty of premeditated murder because he had procured, which is one of the, what a jury needs to find in order to convict of aiding and abetting. So what counsel argued was that basically with premeditation, you're saying Joe commits an intentional killing of a human being and is premeditated. If you want to also hold Sue responsible, you have to say Sue committed an intentional killing of a human being that was premeditated by procuring Joe to do so. Or another way of saying it would be that Joe committed an intentional killing and Sue procured Joe to do so. So in order to find someone guilty on a theory of aiding and abetting, you're really adding in another circumstance, another fact that needs to be found by the jury. And the other fact is basically that the person aiding and abetting has the mental state to commit the crime and that they then commit an act in order to assist in that crime. So basically aiding and abetting is a theory saying when you have a concerted effort by more than one person or a group of people to commit a crime, we're not going to distinguish between the principal and the aiders and abettors. They're all liable under our law. So it's on that theory that the state prosecuted Mr. Alston. The state also prosecuted for a conspiracy to commit premeditated murder. And that's what defense counsel said. This is a conspiracy case. That's what the state's basically alleging. And an overt act in furtherance of the conspiracy. And the state charged that the overt act was the killing itself. And that's what the jury was instructed on. And that not necessarily that one of the conspirators committed the killing. It didn't specify who. So Mr. Alston or another committed the killing. So the conspiracy is there was an agreement between Joe and Sue to commit an intentional murder that was premeditated, and Joe or Sue killed a human being. That's basically what the state had to show in order to prove conspiracy. And so counsel argued to the district court that those, basically two theories, that those are identical offenses because they're both requiring the same things for the state to prove. And also that the conspiracy was actually the more specific crime in this case, because that's basically what the state alleged. And I think the law is somewhat changed on this. I guess the underlying question here is how has the legislature defined the offense and legislative intent? And this court has used certain rules such as the Schoonover same elements test to try to discern what the legislative intent is. There was, when at the time of Schoonover, the statute, which is 215109B, basically talked about you can be convicted of the crime charged or a lesser included crime defined as a lesser degree of the same crime, or when the lesser contains all elements that are in some of the elements of the greater. That was the test. With the recodification in 2011, the legislature added in two other provisions, and basically it brought in a provision, this is subsection D, that is basically the specific general doctrine that this court was a court doctrine for years. Well, it's now in the statute, and basically said it's when crimes differ in that one prohibits the conduct generally and the other prohibits a specific instance of that conduct. You can't convict of both, and you have to be sentenced with the more specific. And this is what counsel argued below. And then the subsection E is the identical offense. You cannot convict of identical offenses based on the same conduct. And so that's somewhat changed the analysis because, again, by bringing these provisions in, the legislature is providing more legislative intent of when multiple punishments can be imposed. In other words, more than one crime for the same conduct.
Okay, so I want to be able to get a handle on this. So the first issue is the multiplicitous convictions, right? That's your first argument. So when we start with multiplicitous convictions, then what we're saying is that, we go to, we have this analysis and say, do they arise from the same conduct? By statutory definition, there is one offense. And then we consider if it's a single statute or multiple statutes. Here we have multiple statutes. And so we employ the same elements test under Blockberger, right?
That's the Schoonover test under the old version of the statute when you only had the subsection B. That test was developed before the legislature added in these additional two subsections.
Okay, so we don't use the same elements test.
I'm not saying not to use it. I'm just saying that there's not case law that directly says it applies. So Schoonover was applying that to with the subsection that says all elements are identical to some elements of the greater crime. And talking about Schoonover was identifying when the offenses were identical would be on the same elements test. Although there's also case law that says that you have to look at the offense that's being prosecuted. So you don't look at all elements of the crimes and comparing them. You look at the elements that are actually charged, because some crimes have different ways of committing the crime. So you look at the facts of the case and what are the elements of the crimes that the state was alleging. And then you look at those elements.
Okay, so when we're looking at those elements,
but our argument's under subsection E, which is the new statute that's come in that says not convicted of identical offenses based on the same conduct. And I'm not necessarily arguing to you that you shouldn't apply the same sort of tests that you've developed in determining whether they're identical, but I'm just pointing out that there's no law either way on those new subsections about
identical offenses based on the same conduct.
Right. And we had the identical.
Do I understand you to say that the elements test could fit there? I mean, that identical offense could be same elements.
It could be. We had the identical offense doctrine for years, and it's based on due process. And basically it's saying if you're a defendant and you're saying, I'm going to do this conduct and this is the crime I'm going to be convicted of, and this is the penalty I'm looking at. So if you have two statutes and they both cover the conduct, they're identical offenses, under due process, the defendant should be sentenced to the more lenient penalty provision. So that's the doctrine that this court applied for years and using the law that I talked about. And now the legislature's brought this in. But the legislature says the state gets to choose. So if you look at the statute, it says the state can choose. You can't convict of identical offenses based on the same conduct, so the state can choose which one, just not both. And that conflicts with the identical offense doctrine that this court applied for years.
Don't you to win have to get to a factual comparison? Because the elements of conspiracy are different than the elements of murder, even with aiding and abetting. It just happens that here, the aiding and abetting act was, the conspiratorial act, I guess, also resulted in a murder. But the conspiracy statute doesn't require that murder. It just requires
An overt act.
overt act.
Okay, and my brief took exception, I still take exception with it's the Mincy case from 1998 that says they're different because aiding and abetting requires actual participation. And I disagree with that because you can procure, obviously there wasn't direct participation here or actual participation. So I don't think that's correct. To me, it's kind of like the capital murder case.
Let me interrupt very quickly. So under the facts, we did have evidence that he made a phone call, that the defendant in this case made a phone call and directly assisted in committing the murder by telling James, that's how I called him in here, where the victim was.
Yeah.
The victim was in the driveway. And so then they went to the driveway that was next door. And then they said, okay, well, now he's left. And here's the route he took when he left. I mean, that's pretty much participation.
Right, but there wasn't direct evidence of that. So for example, the phone record showed a phone call had been made, right? At the time but it didn't give us the contents of the call. At the time that Payne, the deceased, left, the woman and the man who also could have, who was her, I'm going to have to, the man who was the other person who was involved with the woman, okay? So the man and the woman come in the house. It's the other man who's on the phone. It's Clayton who's on the phone. It's not Mr. Alston. Clayton's agitated and Clayton's talking to somebody on the phone. That was a defense that Clayton could have been the one doing everything you said. Mr. Alston was standing at the window. He wasn't on the phone. And he said to somebody, oh, he's leaving now. But Morrison, the woman, didn't know who he was talking to. She just heard him say out loud. So I think when you're talking about a phone, you're referring to the fact that Morrison claims that she later saw a text on Mr. Alston's phone that said, job done.
But what about the thing that said, I'm gonna, not job done, but my guy gets the job done, or, you know.
That was a friend of Morrison's or an acquaintance of Morrison who testified to the next day after the shooting, that asked Mr. Alston if he was involved in it.
No. This is before, when they were making the plans. And he said, my guy
Oh,
gets
and I
the
walked
job
up the
done.
stairs. So then I'll walk up the stairs, so
Right,
three of them. Now I
right.
walk upstairs, my boys get things done, right?
Right.
That's it. That's the evidence. This is all very circumstantial.
But so what? It's circumstantial.
But
I
it
mean,
does-
this is participation.
Right, but it doesn't really change the analysis because we don't know which theory the jury went with. We don't know if the jury said, we're convicting him of aiding and abetting because he procured, or we're convicting him of aiding and abetting because he aided, right? We don't know, because the verdict doesn't require us to, it doesn't require them to say, right? This is all just instructed, one instruction.
But we
So
do know that there were two separate counts and that they convicted him of the aiding and abetting and the conspiracy.
But it's all based on the same thing. I mean, based on the state's
They have
argument.
different elements.
Well, they don't. If you look at, if you say, in order to procure, you need an agreement. If you have a group effort, for aiding and abetting, you've got to have a group effort, right? In order to have a group effort, you've got to have, I mean, it's an agreement. Yeah, if you ask somebody to commit a crime and they say, yes, I will, that's an agreement, right?
Right, but one is asking, okay, let me look at what we have here. One is asking,
Mhm.
and the other is agreeing okay, I'm part of the team.
Mhm.
Advising, hiring, counseling, or procuring is
Mhm.
different than, yeah, let's go get them, being part of the huddle. Being part of the huddle, is a conspiracy, but procuring, now
But-
I lost it again.
I
but
understand what you're saying, but
Yeah.
the way in our case law, agreement can be inferred from the circumstance. Doesn't have to be like, oh, I'm agreeing to do this with you. A jury's told they can just infer there was an agreement. So if people act together, you can infer an agreement from their acting together. I mean, it's.
Along those lines, isn't there a more fundamental problem, it seems to me, with your argument, which is that aiding and abetting is not a crime. And it's a theory of vicarious liability. And doesn't
Right.
that, I mean, so how
Well,
do we
it's not-
have any identical offense?
It's not a crime. We don't this court has not, in the past, has not labeled it as a crime because the state doesn't charge it. And so that's why it's not. But
it's-
jury's got to make the findings. I mean, I don't know what you want to call it. It's part of the offense.
Right, but if we look at legislative intent, I mean, the intent of the conspiracy crime is to punish the agreement.
Mhm.
That is the crime, is the
Mhm.
agreement.
Right.
The reason we punish homicides is because it's a killing of another person. And those are two very different crimes.
But the state obtained its conspiracy conviction based on the commission of the completed crime. That's the only overt act they alleged. They didn't have to prove any other overt act. It's not just an agreement to get a conspiracy. You got to have an overt act.
Right.
And the only overt act that the state
And you're
proved
just saying
was a completed crime.
that you don't
So-
think the legislature intended to punish those as two separate crimes?
No,
Agreement and then the completed crime.
how do you know that they intended? I mean, there's some states where by statute, how do you know that they intended? That's what we're trying to discern, right? You're assuming they intended. There's also an argument to be made that they intended a conspiracy but the completed crime is not committed. And so they only they need to have something that falls short. When you don't have the completed crime, we still need to punish the attempt. We need to punish the solicitation. We need to punish the conspiracy. And that's what it's for. It's really saying if you take some initial steps towards this, but you stop or it doesn't get done, you're still culpable.
Sure.
Yeah. So I mean, that could just as much be the legislative intent.
As you pointed out at the trial court level, the general specific was the focus. Are you abandoning that on the people?
No, it was one of the arguments. And again, I'm not abandoning it. I think it's a harder argument to make. Probably would only echo counsel's comments about it being more specific because this was the specific conduct that the state alleged was the conspiracy. And then the state said, through the conspiracy, he procured these men to do this. And that's why he's guilty of premeditated murder. And so counsel argued below that the conspiracy was more specific because it covered the agreement and the completed crime. But, I see them as being identical the way, so I think that's a little bit tougher argument to make, but it's harder argument to make than other cases this court has had dealing with specific in general. But I mean, it's true. I mean, just basically the state's theory of this case was a conspiracy. I mean, counsel's not wrong about that.
And if you were to prevail here, one outcome would be that you simply could never convict somebody in a straight murder for hire scheme of conspiracy and murder.
If you allege a different overt act.
Why does that matter?
Well, because then you have to prove an actual conspiracy. I mean, the state had trouble.
And let's say we have a written contract.
You got the agreement, but the state, for example, proving what was the overt act short of the completed crime here, right? So maybe an overt act could have been,
you
what the
think
justice has suggested that he conveyed the guy's leaving now.
The state's selection of the overt act changes whether it's an identical.
Yeah, because once you charge the completed crime as the overt act, you're always going to get a conspiracy conviction. They should have to prove something separate from that.
Other than the completed offense.
Right.
Yeah.
I'm out of time. My microphone issues, so I think I'll sit down unless there are questions.
Good morning, may it please the court. Again, the state appears by Deputy District Attorney Jody Lipton. If we're just going to focus on issue 1, the state's position here is that the aiding and abetting theory and the aiding and abetting premeditated murder here and the conspiracy to commit premeditated murder are not multiplicitous. Our brief outlined the same elements test. And I guess I didn't see any other tests being offered by the defendant, so we went with the Schoonover test, and I think that's how it was argued below. Also in the motion to dismiss. And
Well, what do you
then-
think about opposing counsel's, I guess, submission that in order for it not to be multiplicitous, you have to allege a different overt act besides the completed crime?
And I guess I didn't pick up on that in the brief, but I guess I would say that doesn't matter. I mean, if the elements are different, then
Well, would you have had a conspiracy if the murder wasn't committed under your theory?
you still have an agreement, and I think the agreement is the focus.
But what would have been the overt act?
It could have been the phone call he made saying,
But was that, she said that wasn't, he wasn't on the phone saying that. I don't remember the facts that detailed. He was at the window. I thought he was on the phone saying that, but she said he was at the window and somebody else was on the phone.
my recollection is that Mr. Alston was at the window, Mr. Clayton was on the phone.
Right.
I think,
I
Who's the
didn't
other
remember
man?
that, right.
and he was saying how this had him messed up. He was upset. Something had him messed, his comment, Mr. Clayton's comment was, this has got me, effed up.
Right.
And then Mr. Alston was saying he's leaving now, and Miss Morrison just hears him say that. She doesn't know who he's saying it to. But I think the inference is,
But he's not on the
Clayton's on the
phone.
phone.
He's not on the phone.
that's my understanding, but I think the inference is.
And how could
Clayton's
that
on the-
be, how could that be an overt act then?
He's still giving the direction
To who?
to Clayton, who's on the phone with presumably James Boatwright.
Well, was that communicated?
I think the inference is there based on, we have the phone records of all of the phone calls between the three and the text messages. So yes, I think so. But just looking at this from a same elements test, the elements are different. So I don't think we need to get into the facts of which one. As far as
Well,
procuring.
opposing counsel argued that the elements aren't different because if the state chooses an aiding and abetting theory, which relies on an agreement, and now their elements are the same. How do you respond to that?
And I guess it's not I guess I don't know where the agreement is coming in from the aiding and abetting. Procuring is agreeing.
That's how I understood.
Yeah, I guess I would
opposing
just-
counsel's argument.
I guess I would disagree with procuring is agreeing. Procuring is separate from an agreement.
What if it was a murder for hire and you had a written contract? That's procuring and it's an agreement.
I hadn't really thought about that. I mean, I guess it would be, but I don't know that you have to. I mean, I'm not sure if that makes it just the element of the crime in procuring.
How many written contracts are there?
Yeah, I mean, I guess I don't have a better answer than that, Your Honor, just that,
But just to sort of explore defense's argument to its full, it does strike me that there's something there. I don't know if the elements are identical, but it does seem difficult to think of a procurement that does not involve an agreement. If you, let's put it this way, let's just say there was procurement and the state charges conspiracy. I mean, you're going to have all kinds of evidence of an agreement.
right. I mean, I guess that goes into, and aren't we really? This is a theory. of premeditated first degree murder. So you're looking at the elements of, I mean, if we're looking at the instruction and the elements of murder, I mean, the aiding and abetting theory is, yes, that's what we have to prove, but it's not in the actual instruction, I guess. So we're looking at the elements of the crime from that
Yeah, so your
standpoint.
argument is kind of goes to my earlier question, which is, look, this is a burden of proof, but it's not an element of the crime.
Right.
And conspiracy doesn't involve, in this case for the murder, aiding and abetting, you had to show premeditation, right?
Correct.
And in the conspiracy, even though the overt act was the killing, there's no premeditation required in the conspiracy?
I mean, yeah. I'd have to look at the conspiracy instruction, but I mean, it's the agreement really is the focus of the conspiracy is what I understand.
So there
But-
would be no premeditation required.
Yeah. Well, he agreed with others to commit murder in the first degree is the first element. And did so with the intent that the murder in the first degree be committed. So,
But the mention of premeditation is not in there.
I mean, well, it's set out in the definition of murder in the.
Yeah, you have to have the same,
the-
you have to have the same state of mind as the,
Well, under the
behind
aiding and abetting, but I didn't know under the conspiracy.
It references the murder in the first degree instruction
Okay.
too. Yeah, back in.
So who has to perform the overt act? Does it have to be the defendant, or can it be person, James, who's driving over to?
I think the statute says it has to be proved by such person or a co-conspirator.
Either one.
I believe that's what the statute says. Back to my notes. I don't know if I want to get into the second issue unless the court has any questions on it. It was just about the district court abusing its discretion when it denied the defendant's motion for new trial. We would just ask this court to affirm the denial of the motion for new trial based on the improper admission of the evidence and the prosecutorial error claims that were made there. We would argue that the state did not, or I'm sorry, the district court did not. There was no error of law, no error of fact, and the decision by the district court was not unreasonable in denying that motion for new trial. Further questions? I don't have any more presentation.
I think on the question about aiding and abetting isn't an element. It's part of the offense that the legislature has said the state has to prove in order to convict. So to me, that's what that's the concern here is what is the offense? How does the legislature define the offense? And it's there in the statute. The person is criminally liable for a crime committed by the other if the person does X, Y, and Z. So that's how the legislature has defined the offense. And that's what governs. On the overt act and furtherance of the agreement, to me, it's kind of like the capital murder cases where for capital murder, it's an intentional premeditated killing done in the commission of rape. And then this court has said, therefore, you can't also convict of rape. That would be multiplicitous. So it's like that. And it's the same thing with the aiding and abetting. You're adding in something, you know, intentional premeditated killing and you procured somebody to do it. You have to add in something else. And when you add that in, that's where the multiplicity comes in. And when they added into the conspiracy that you had the agreement and one of the conspirators committed the killing, you're adding that in. That's what the state's choosing to do. They're choosing to add that in as their overt act.
In 2014, in the Betancourt case, we said aiding and abetting does not add statutory elements that the state's required to prove. And then in Robinson in 2012, we say aiding and abetting statute shows it's an assignment. This is what Justice Stiegel said. It's an assignment of criminal liability rather than creation of a distinct element of a crime. Extends criminal liability.
Right, again, but it's something the state has to prove. It's the defining of the offense that the state has to prove in order to get a conviction. If you don't want to call it an element, that's fine. It has a mental state, it has an act, which are things we usually think of as elements. But again, it's semantics. It's something the state has to prove, and that's what matters.
And it was incorporated into the elements instruction, right, for first degree murder with the or another language, or was that?
It's actually instructed separately. And it's
Correct, but the
basically- yeah.
hook to get to that separate instruction is the or another language in the elements instruction for, or was that not included?
Sometimes courts will say, Joe or another person who, Joe is criminally responsible for.
Right,
Sometimes they'll say that, sometimes they'll just say Joe, and then they'll say, Joe's responsible for what Sue did.
that's why, I guess, do you recall from the instructions here, which version was used?
They just did it straight up that the instruction read that, Mr. Alston, the defendant, committed a intentional killing, and that it was done with premeditation. Obviously, since Mr. Alston, the only way you could find that from the evidence is if you then go back to the instruction that says you're liable if you procure somebody else to commit a crime, then you're also liable for the crime that's committed.
If you prevail on your multiplicity argument, what are you asking for?
Well, we're asking for the court to only enter a conviction for the conspiracy charge. The statute says that with identical offenses based on the same conduct, the state can choose which one to enter a conviction on. But under this court's identical offense doctrine, under due process considerations, a court can only convict of the lesser. So the statute conflicts with this court's rule, which is based on constitutional considerations. So obviously, we believe that the constitutional consideration of due process
So
outweighs the statutory.
would we have
qualifier.
to find that statute unconstitutional to get to that outcome?
Well, the part about the state getting to choose, that's the part that, just that part, not the rest of it.
Just that part.
Just the part about the state choosing, because this court, in your case law, based on due process, the defendant gets the benefit. When you have two, statutes that cover the same conduct, they get the benefit, they get the lower penalty. That concludes my comments. Thank you.
Thank you. The court will take this case under advisement.